So this webinar is going to focus on Sunshine Week. Now, Sunshine Week was actually created by the American Society of Newspaper Editors. And, when we think about the importance of open government, we have all sorts of different ways to celebrate, but the best way to celebrate is actually to do what you can to be just a little bit nosy and to get more information about what is actually going on in our government so that we can actually truly participate. And so I wanted to welcome you today. We're going to just get started. So we are very fortunate. We have some experts that are with us today. Gary Daniels from the ACLU of Ohio is going to be leading us through a good overview of, what exactly is Ohio Sunshine Law? What's up with Ohio records? What's up with open meetings? And then the thing that I wanted to highlight about Gary is when he is at the Statehouse, he always tells people he is the chief lobbyist of the ACLU Ohio. And when you're at the Statehouse, almost everybody is a consultant, or they're very kind of careful about saying that they're a lobbyist loudly. And I've always really liked that Gary's out there and he's just like lays it on the line and says, I am here to advocate for the people of Ohio. The next person that I wanted to highlight was Sandy Theis, and Sandy is somebody that many of us will be familiar with. She was a Statehouse reporter for many years. She was with the Cleveland Plain Dealer, and she was basically the head of the Statehouse press corps, their bureau. So she was responsible for making sure that everything that was going on at the Statehouse was getting, into our set of information that was available. I'm not saying this terribly well, but I'd like to highlight, that Sandy has this kind of long history of doing public records requests, working to understand what they actually mean. She's now with Theis Consulting, so she started her own firm. And before that, she was with Progress, Ohio. I am Catherine Turcer, Common Cause, Ohio, she who trips over her own tongue. And then I was also going to highlight, there's the wonderful Lisa Wurm, who's with the League of Women Voters of Ohio. Now, her focus is really on redistricting. And I wanted to highlight, as we're going through all of the information today, that this is the year of the map making. This is the year where we will be making, really important decisions. So the Ohio Redistricting Commission will be creating state legislative maps, the Ohio House and the Senate maps, and the state legislature will be creating the congressional maps. And one of the things that we know is that during 2011, one of the major obstacles to actually getting fair maps had to do with the lack of transparency, the inability for the public to really participate and influence the process. And so this year, and possibly because of the census deadlines, the very beginning of next year, when the official map makers are creating these new districts that will last for 10 years, we need to be able to participate, we need to be able to weigh in, and we need to understand what is actually happening at the Statehouse. And so this is our kickoff, getting all ready and preparing for 2021 map making. And so welcome everybody, happy Sunshine Week. The next slide, you will find an overview of what we're actually going to be doing. I suppose first we have a political cartoon because I love them. I want to just let everybody know happy Sunshine Week, and also the importance of transparency and going after government corruption. It's also really important so that we can actually participate. It's that thing of like, well, how in the world can we actually influence the map making process if we don't actually know what's going on? And so on the next slide, you'll find an agenda. Oh, so you've already participated in the welcome, so I'm glad you all are here. Gary is going to do an overview of Ohio Sunshine's law. Lisa is going to be facilitating questions. So please put your questions in the chat. If you're not muted already, please mute. If you wondered whether this is going to be recorded, it's going to be recorded, and we'll send a recording to you after this. We'll also include some action items that y'all can take. You'll notice in the corner, I highlighted a quote from the 6th governor of Ohio, Thomas Worthington. I think it's really important for us to see transparency in government as essential to the very beginning of our government and the connection to open government and good government. Then we're going to have a conversation about how to do a public records request with some good tips from Sandy Theis. And then Lisa Wurm is going to cover virtual testimony. Right now, we can't actually do virtual testimony, which is a challenge. I don't want to say it's unsafe there exactly, but until we are properly vaccinated, it's a little bit scary to go there. For those folks who've wondered how long this will last, this is a noon webinar, so we're hoping to wrap up by 1 o'clock. Some of you may have questions afterwards, and Gary has kindly offered to stay a little bit after if you have additional questions. And then we're also going to provide our emails so that if you want to follow up with specific questions, you can. And with that, Gary, I'm going to hand it off to you.
Thank you, Catherine, and thank you everybody for attending this. I don't know how many of us there are, but for those of us interested in issues of government transparency and accountability, Sunshine Week is like our Super Bowl week. We appreciate press coverage of Sunshine Week and what it means, and from time to time, I can't say that we do it every year, but we like to put together programs of this type, and I'm very thankful that Common Cause Ohio put this together, and that I get to participate with not only colleagues but old friends Catherine, Sandy, and Lisa. So I'm going to do sort of a crash course of public records and open meetings laws, that is sunshine laws here in Ohio. I like to think I'm not totally biased, and what I mean by that is I think the laws are rather easy to understand, and so hopefully a crash course today will suffice in everybody learning more about this area of law. But it is a crash course, and so if you have additional questions, you want to look at this a little bit more, you see the slide there. The Ohio Attorney General on a yearly basis or nearly yearly basis releases a Sunshine Laws manual that spells this out more. And then the ACLU of Ohio, where I am from, we also have a publication that was last updated in 2016, but all of that information is still relevant today. Next slide, please. So I'm going to boil this down very easily. I've got on the slides sort of the very basics, but I will talk about them a little bit more. So what a public record is actually really easy. As you see on the slide, it's information on fixed media created, sent, or received by a government entity that documents government functions, decisions, procedures, and related. Next slide, please. So what all that means exactly? What does it mean, information, fixed media, what have you? So information can mean lots of things. The important thing is that it's part of a fixed medium. And a lot of people, when they think about public records, traditionally they think about paper records and paper documents. But Ohio's public records laws are not limited to paper documents. So in the grand scheme of what all you can request, for instance, I threw out some examples there: contracts, audits, transcripts, studies, basically information that the government is relying on to make decisions. And there's a whole wealth of things available, and I will get into some examples of what the ACLU of Ohio itself has used public records for in the past and currently. Fixed media, again, people think in terms of paper documents, but also think about videos, emails, texts. These are all available under Ohio's public records laws, and so you shouldn't think about or limit yourself to just strictly paper documents in a 21st century world, of course. Government entities is both easy and not so easy with respect to Ohio's public records laws, but government entities is essentially what you think they are in the most basic form. So city council, police departments, public schools, these traditional government entities that keep records, which may reveal different workings that go on in those entities. Where it starts to get a little bit confusing, certainly for all of us engaged in this, is there has been a movement over the years and over the decades to do what are traditionally government functions, but they're performed by, for instance, a nonprofit entity or a for-profit entity, but they've been tasked with doing that government function. So the Ohio Supreme Court did a number of years ago lay out a functional test for when private entities or quasi-private entities or quasi-public entities are subject to Ohio's public records laws. And essentially it has to do with the intermingling and the intertwining with what they are doing and how closely it relates to the government function, government spending, government oversight. But I'll say, just because a entity is not a strictly government one, again, if they are performing a lot of government functions, that could make them subject to Ohio's public records laws. And that is a popular question or issue that often comes up in presentations or discussions like this. Regarding the functions, the decisions, what exactly are you looking for? Are you entitled to in these records? It could be everything from why did they make a certain decision? What info did they rely on? So when they, decided, let's say, to build a shopping mall on the east, fund, give tax breaks for, build roads to lead to a shopping mall on the east side of town rather than the west side of town, as was originally planned, let's say. Why exactly did they do that? There should be documents available. That's a very sort of mild example. I don't know how many of us care about that particular issue, but it's just an example of the types of information that you could get and the conclusions you can draw from receiving them. Internal communications are also fair game. You can ask for emails about certain topics that might have been sent on certain dates to certain parties. Internal communications isn't only emails, of course. It can be memoranda. It can be any number of things. Again, as long as it documents what it is that government entity is doing. But of course, with all of this, whenever you're talking about law and the legal landscape, there are exceptions. And I will say, in talking about the Ohio's public records laws and public records laws in general with colleagues around the country, I'm led to believe that Ohio's law is very good as written. But part of the problem is how the courts interpret it, which we may get into here as the program goes on. But how the courts interpret Ohio's public records laws and what we're entitled to can oftentimes be different or dramatically different than what the plain letter of the law says. But among exceptions, I looked today before this to see how many exceptions currently exist. Because the legislature is always adding more and more. We're up to at least 39 exceptions at this point, and there are some sub exceptions in there. Basically, so you've got your A1, A2, A3, all of that. But so that's why I say at least 39 exceptions. Now, all of these exceptions aren't bad or necessarily bad. Some of them are, absolutely, and they keep information away from the public. But among some of these exceptions, I mean, this doesn't apply to redistricting, but I can tell you one of the exceptions that people get tripped up by the most, and we get the most questions on, is what we call the CLEAR exemption. And CLEAR is an acronym for, let me get this right, Confidential Law Enforcement Investigatory Record. So the idea is that while law enforcement is examining something, investigating something, working up a case, that the general public, we the general public, are not entitled to those records. And that makes, of course, a certain amount of sense. If you're working with informants, if you're working with different tactics to investigate a person or discover who they are, you might not want, in a worst case scenario, that person to know that you are investigating them and how to do it. But without the CLEAR exemption, they might be able to discover that. The problem with the clear exemption often is that prosecutors, police, and other law enforcement agencies read it very broadly, much more broadly than the ACLU of Ohio or newspapers or other people would like them to read it. And so, that's resulted in litigation around Ohio about exactly how broad that exemption is. There are a whole host of other ones where the government might, or a government entity might have documents or information in their possession that we're not entitled to because those exceptions have been written into Ohio law. So for instance, DNA records. If you are arrested for a felony offense in Ohio, you get your DNA taken, or at least under the law, you should, as far as the law is concerned. So there's a government entity out there collecting and storing, at least for some time, with certain people, their DNA, or DNA sample, I should say. That is not available under Ohio's public records laws. The Department of Youth Services, other juvenile court proceedings, things of that nature, to protect the identity of juveniles who we recognize under the law as different than adult defendants in court or legal matters. Those are largely kept under wraps. Adoption records, security and infrastructure and anti-terrorism type records, different communications and proceedings information from the Civil Rights Commission, all kinds of records in this 39 exemptions, and a very popular one that is leading to more and more exemptions under Ohio's public records laws is removing familial and residential information of different people that perform certain jobs or duties within society. So it started out, for instance, like as police, and then it eventually reached judges, and then parole and probation officers, and our legislators keep thinking of new people that should be fall under this exemption, and we're continually seeing legislation of that type. And that is where sometimes the issue of government transparency and accountability collides, let's say, with personal privacy of people. So those are just some of the exemptions, but you can look at that Attorney General publication, the Sunshine Laws Manual. You can go right to the Ohio Revised Code. Section 149.43 is where you will find the public records law. And again, I think this is rather easy to understand. It's not written in like legalese in a way that people who are not tasked with following this and doing this on a daily or weekly basis. You will find those exemptions all spelled out in 149.43. Now, when you're making a public records request to a public entity, they do have certain responsibilities under the law. And I'm sure we'll get into that a little bit more with Sandy as we discuss how to make a public records request. But very generally, they have to have a retention schedule for these records. Generally speaking, I'll get into that a little bit. But they must make these records available for inspection. If you were to go into your local police department or school board building and request certain records, and they tell you, well, they're buried under a mountain in Montana, that's where we keep them. I mean, that's not acceptable under Ohio's public records laws, because then those records exist in a place where nobody can functionally get to them. Under Ohio law, it is written in a way, essentially, that you could have immediate access to these records with no delay. But this is also the real world. And so we know if you are requesting certain records, it may take time for the secretary or the clerk or whoever is the custodian of those records to find them, look them up, and get them ready for you. This can cause some headaches if you are trying to track down records quickly. But if you're looking from something for 20 years ago that they might still have, that might take some time. Those might be records that in fact are stored off-site somewhere. And this has led to some discussion, among litigators, among lawmakers, among the records keepers, in that while Ohio's law is written pretty broadly that you can have access or almost immediate access that you're entitled to with these records. Again, that's not the way this works. And so we always urge patience with this. A very real world example, we were at the ACLU of Ohio many years ago investigating something that happened in a very small local village. But the village building, or whatever it was called, the clerk was only there for half a day once a week on Wednesday afternoons. So if you missed her that Wednesday afternoon, you had to wait until the following Wednesday to talk to her to get these records, or request them even. That's just an example of where the real world can collide with what the plain letter of the law says that you are entitled to. What they don't have to do, what these government entities do not have to do. One of the most popular questions or complaints that we receive at the ACLU of Ohio, or that I become aware of through programs like this, or talking to others, is keep in mind when you are requesting information or thinking about requesting information, the government entity is under no obligation to create records for you. What you are requesting is existing records. So it is not unusual for people to request something that the government entity does not have because it does not exist, or it does not exist in the format that you want. That is, if you are requesting certain voter or voting information, it might work best for you to have it laid out in a document all nice and neat and easy to read. But if the government entity does not keep that document or those documents in that format for themselves, again, they are under no obligation to create something, to arrange something, to format it in a way that is the most pleasing or the most helpful to you as a person requesting that. They also need to have a process available for doing this, for requesting these records. We will get into that again, I'm sure, in a little bit here with Sandy about some of those helpful tips and what the law says and how it works to your benefit and how it does not. But essentially, with these public records laws, you are entitled to a whole host of information out there. I think many people are oftentimes surprised how much is available to Ohioans with regard to their government and what some of these things can reveal or uncover. I encourage people to use public records laws liberally and be a pain in the butt if you need to be with your local county or state authorities here in Ohio, which I will also mention because there is oftentimes confusion. Ohio's public records laws is not FOIA. You often hear them used interchangeably, that somebody in Ohio is filing a FOIA request. FOIA is federal law. It's the Freedom of Information Act, and there is a slightly different process for requesting records from federal government entities, agencies, and offices. Now, I understand people use it interchangeably. Many times when they say they're filing a FOIA request here in Ohio, they really mean they're doing something under section 149.43. So just be mindful of, technically speaking, when you are requesting records in Ohio, it is not technically a FOIA request. You should also know that, we'll get into that with Sandy, I'm sure. So some of the more burdens that are going to be on you, the requestor, when you're requesting information. Next slide, please. So there's while public records get all of the attention or much of the attention when it comes to sunshine laws, there is, as mentioned, also an aspect of open meetings. We're not talking about just public records, we're talking about open meetings. And so that first sentence there on the slide, I would like to think is as complicated as the law gets. If you're a public body, you have to hold your meetings in public. But of course, it gets a little bit more difficult than that, but not much. So for instance, when we're talking about public bodies, we're talking about decision-making entities, and that's important. You're talking about entities, perhaps like a city council or a school board, that is going to be voting on something or is going to be implementing something that affects you or somebody or all the rest of us. Where this distinction can come into play is you might have a government body like a city council or a school board that is made up of subcommittees. But if they're there just to gather information or consider certain things, that doesn't mean that their meeting falls under, or their entity falls under Ohio's open meetings laws. The answer, as people will tell you, the joke that has been in existence for a long time, probably as long as the legal profession is, the answer to any legal question is, it depends. And it does depend with, that's certainly true with public records and open meetings laws. So again, when you're talking about public bodies, generally speaking, you're talking about decision-making bodies. But there's been a whole lot of debate, a whole lot of litigation as to where exactly that line is drawn. For instance, the ACLU of Ohio filed a lawsuit a number of years ago and unsuccessfusly was able to challenge Cleveland City Council, or I'm sorry, Cleveland School Board had been setting up quasi-government public citizen entities, task forces, let's say, to make larger recommendations to the public school board regarding, how they were going to conduct certain things. Our contention was that their meetings and their documents were subject to Ohio's public records law, but particularly with the meetings, we didn't get very far in court making that argument, because the court said, and defendants argued, that they were not a decision-making body. They're only making recommendations to the larger school board. Now, with regard to meetings, this is all, again, intertwined and intermingled. Again, you're talking about mostly sort of those classic examples of the school board, the city council, the county commissioners. It's a prearranged gathering with a majority of the members of that body present to discuss public business. So again, these subcommittee meetings, other types of government entities that might get together that don't have decision-making power, that don't, the gathering is not prearranged, things of that nature, they are not subject to Ohio's open meetings laws. Now, where this can get a little bit tricky and where you see violations of these laws is what you can't do, and what Ohio's open meetings laws are meant to prevent is, for instance, a round robin meeting of sorts or discussion of sorts among, let's say, school board members. So let's say you have a 7-member school board all in one office. You can't, as 1 or 2 people, go around office to office and discuss business with people. That has to be, under law, discussed in that larger open meeting. So you can't just, walk around and say, hey, how are you going to vote on this? What are you going to do? What are your thoughts? These discussions that should be done in public, that sort of round robin way to avoid the open meetings law, that is unacceptable under the law. Problem is, of course, I suspect that this goes on and much more frequently than we all know, or those entities would be willing to admit. Like public records laws, there are exceptions. The big exception, the major exception that you should be aware of, is when they retire into executive session. And that means that they can interrupt the meeting, go to a separate room, or kick everybody out of the current room, and have discussions about any number of things away from the public view. Again, these are baked into Ohio law. So it could be about personnel decisions, it could be about intellectual property, it can be about the purchase of real property. There are several exceptions in there, but the big one that gives everybody heartburn is often this executive session exemption. And again, just like with a lot of open meetings laws and some public records laws, it requires a lot of trust on behalf of us, the public, the citizens, that the government is not trying to circumvent these laws behind the scenes. So with that, I don't know if we want to take questions right now and also have some at the end, but we did reserve some time here, a handful of minutes, 5 minutes about. If anybody has any particular questions out there that can be answered now, As Catherine said, I will stick around after this is over at 1 o'clock if people have other questions. But these are the basics of Ohio's public records and open meetings laws. Please refer to the ACLU of Ohio publication or the Attorney General's publication. Again, I really don't think it's that much more complicated than I laid out here, but there is a lot of easy to understand and digest information out there that should help improve your understanding of these laws here during Sunshine Week.
Well, thank you very much, Gary. Yeah, we will, I'll read you off some questions. Again, my name is Lisa Wurm. I'm with the League of Women Voters. I'm working on redistricting. So while we will address some of your general questions, we'll also be talking specifically about redistricting since that's what we're focused on this year too. So Gary, my first question would be regarding the redistricting process that's laid out in the Constitution that we voted on a few years ago and passed. These are all new provisions for us. This is the first time we're using the new rules. And so in those rules, in the law, it requires, some public meetings to be held regarding the maps. Would these laws apply to those redistricting commission meetings?
Yeah, that is a great question, particularly in the context of what I'm sure everybody here is interested in, and it's the redistricting, gerrymandering issues that are perpetually going on here in Ohio that we hope to end. Luckily, Catherine, when we discussed this issue yesterday, clued me in that there is these new provisions regarding redistricting, and so Catherine has assured me, and because Catherine is an expert on these issues, I was happy to hear that indeed these meetings that are required do fall under Ohio's Open Meetings Act.
And what's really cool is that there are additional meetings that are literally in the Ohio Constitution saying that we need hearings after the official map makers propose maps. This becomes really important because what happened in 2011, and certainly in 2001, it was actually worse then, was that a map was introduced and then the apportionment board just said, okay, that's it, we accept this. And there wasn't an opportunity for the public really to deliberate on what was being considered. And there was very little time when it came to the congressional maps in 2011. So in the Ohio Constitution, there are required public hearings, 2 of them for congressional maps and 3 of them for state legislative maps.
Yeah, so at least we'll be able to get, thank you, Catherine. We'll be able to have some sort of transparency. And again, this is all, we're testing, we did the best that we could. And we'll see how this goes. As we know with public records laws, it's all about how they uphold the spirit of the law. So that's kind of what we're focused on this year. So Gary, I do have a specific question for you from the chat, which is someone would like to know that if you request for all communications between 2 parties about a specific topic, like how can you be sure that you've received everything if you're not even sure exactly what you're asking?
Yeah, this will, I'm sure, Sandy will get into this a little bit, and I'll be introducing Sandy for that and also weighing in because, I try to think of who, I was part of the legal staff for a number of years here at the ACLU of Ohio. I sent out just zillions of public records requests for ACLU purposes. But if I can think of somebody in Ohio that's probably sent out more public records requests than I have, it's probably Sandy. It is part of the, I don't know that there is a science to doing this. There is almost sort of an art to doing it, to requesting these records. And the question brings up just a fundamental issue with this, and that is, how do you know what to request when you're not even quite sure what you're requesting? And as Sandy, I'm sure we'll get into, I don't want to scoop her remarks or anything, but you want your request to be as narrowly tailored as possible. The courts have limited, let's say, over time, this idea, and courts are very deferential oftentimes to government entities with this. The courts do not want, and the public entities do not want, and the courts will back them up on this. You can't do a public records request that says, I want all of the emails sent between the mayor and the city council president for the years 2008 to 2015. Now, while I think that you are entitled to those records quite simply under Ohio's public records laws, the courts do not read it the same way. So as much as you can narrowly tailor that as possible, you want to, which now, because I'll also be around for questions at the end, and we're out of time in this particular part, seems to be a great segue into turning this over to Sandy to discuss this all a little bit more. Again, I have been given the keys to the kingdom, and that I will weigh in here with my own thoughts and experiences to make this as helpful as possible. But this is Sandy's show here on this particular part of the presentation, so I will now turn it over to her.
Thanks, Gary, and thank you everybody for coming and for caring about public records. Don't be shy if you're asking for government records. You paid for the records, you pay the salaries of the people who produce the records, and these are your records. So thank you guys for coming and for caring about transparency. Catherine mentioned that I used to run something called Progress Ohio, and it was a progressive nonprofit that was dedicated to government accountability. And we did a lot of the research on the charter schools. And back then and today, they are the subject of national ridicule. And charter schools are public schools in Ohio. So charter school records are public school records. And we had narrowed down from our initial research 4 charter school chains that we were trying to look into. And I saw a column that a teacher named Matt Blair had written. And in the column, he said that while he worked for a Horizon Science Academy, which is part of a charter school chain, he personally saw cheating. He saw the teachers doctor student standardized tests and change the scores. He saw sex games in the classroom and other things. And he tried to do something about it. He said he called the Ohio Department of Education and they didn't return his calls. He emailed the state school board and they didn't return his calls. He contacted the charter school sponsor, and the sponsor is sort of representing the public and is in charge of overseeing the schools. So I looked at this and I thought, oh my God, this is just incredible. 3 of the entities that school teacher Matt Blair approached and complained to basically blew him off. Well, school teachers are licensed in Ohio, just like cops and lawyers and lots of other people. And so I found out where Matt Blair was still working, and I called the school. And I explained who I was and I explained what I wanted. And he called me back that night. And I said, I'm interested in looking into this. Are you still mad? And he said, yes. And I said, here's what I'm going to do. I'm going to file a public records request. And then I'm going to call you and tell you what I found. So Gary talked about the importance of narrowly tailoring your request. Instead of saying, give me everything you have on the Horizon Science Academy, I sent public records requests to the state school board, a public entity, to the Ohio Department of Education, a public entity, to the school sponsor, a public entity. And I included a copy of Matt Blair's column. And I said in my public records requests, I want to know how you responded to his complaints. One of the most important things you need to do is you need to find out to whom you send your request. But because I'm a reporter, I know that. But if you don't know that and you're just a citizen journalist, call the entity that you're requesting from and say, I'm going to file a public records request. Who do I send it to? You can make them orally. I don't recommend that. Do it in writing. And so, for example, the Ohio Department of Education, they wanted it to go to the state superintendent. The state school board wanted it to go to the legal counsel. I can't remember who the sponsor wanted it to go to, but I send those in and you have to document that you sent it in and that they received it. So email helps you do that. And if it's somebody with whom you have an adversarial relationship, and Progress Ohio had a very adversarial relationship with all those charter school people, we also send it certified mail. That costs you a couple bucks, go to the post office, and they will send it to the person, and somebody will have to sign for it. And then you get a copy of the document that they signed for. So you know when it came. So when I send in my public records requests, I always say, dear whoever, in accordance with the Ohio Open Records Law, and then I cite it, it's ORC 14943. I am requesting public records in the possession of your agency. And I mention the agency. And then I try to succinctly explain what I'm asking for. In this case, it was so helpful to just send in this Matt Blair column because it had some pretty newsworthy stuff in it that was pretty eye-popping. And so one of them wrote me back, and they are a public entity. The sponsor wrote me back and said, we don't have to give that to you. We're a nonprofit. Well, that was baloney. But I eventually got back a mountain of public records. If they had copies of it 10 times, they sent me all 10 copies, which is fine. I know I've seen some questions in the chat about who has to pay for them. I always put in my public records request that I'm willing to pay reasonable fees, but I request that they waive those fees. Because particularly if you're getting 10 copies of a government document that's 50 pages, those copying fees are going to add up. And I was working for a always financially struggling nonprofit that didn't have enough money. And the last thing we wanted was a big bill for copy fees. You never know what you're going to get. And one of the things that I got that I found the most eye-popping was they acknowledged in their communications, they knew Matt Blair had called them and they didn't know what to do. They knew he had emailed them and he didn't know what to do. Once his column got published, Bill Phillis, who is an amazing person who has filed the school funding lawsuits, Bill Phillis saw that and my plumber is here, excuse me. And so he sent a copy of it to every member of the General Assembly, every one of them. And he said, what do you think about this? And of course, no members of the General Assembly responded to him, but they did respond. They sent it to the state school superintendent. And so he sent a copy of the column to the sponsor. And the sponsor, like I said, is supposed to look out for the taxpayers. And he sent a note on it that put the cover up in writing. The note said, please answer these questions, which he submitted. And he said, quote, keep your responses brief and positive. So one of the questions that he sent was, Matt Blair says that he saw your teachers cheating. Do you have a policy on cheating? So instead of saying, we saw our teachers cheating, they said, we have a policy on cheating, and here's what it says. They never directly acknowledged any of Matt Blair's specific accusations that he witnessed firsthand as a state licensed teacher. So I called him when I got the information and I told him what happened. And thank God he was still mad. And he helped me find 7 other teachers from the same school who witnessed many of the same things, including an in-class groping game. And they called it, Are You Nervous? And with the encouragement of a teacher, the boys would put their hands on the girls' knees, and then they would move their hands up further and further, and they would say, Are you nervous? Okay. So knowing that Ohio's charter schools were the wild, wild west of charter schools, according to the national press, and knowing that the people in charge of this did not like any criticism, I lined up all those teachers to testify before the state school board. And you're allowed to do that. And you don't have to get permission in advance from that entity, which I knew some people ask for 24 hours in advance, and they have to sign a witness slip, but the state school board just needs one person to sign in. So I signed in on behalf of the teachers, and one by one we took the teachers up there. It was pretty explosive and it was important information, and nothing changed. Some of the members of the state school board were pretty appalled. Their initial response was to go after the teacher whistleblowers because they have to report evidence of abuse in the classroom, and they thought that that groping game was abusive, and they wanted to go after the whistleblowers, which didn't surprise me. But I called all the newspaper editorial boards and I said, really, this is what's happening in these schools? And they're going after the whistleblowers. And so we got that thing taken away, which was nice. But those schools are still operating. Most of them still stink. Nothing has happened. But that doesn't, I'm not trying to discourage you from public records. One of the other things that we did was also a charter school event. And our inspector general was supposedly looking into something called IQ innovation. And you guys have probably heard about ECOT, the electronic classroom of tomorrow, which I think is still the subject of at least some criminal investigations for charging the taxpayers for students who didn't show up. And I filed a public records request with the inspector general, who I personally think is terrible. And I asked for this investigation, and he kept telling me it's almost done. And you can't have it if it's in a draft form. So I got so frustrated by getting strung along, I went to the Ohio Court of Claims, which is a really interesting way to get your public records that you've been trying to get, and have the courts order them to do it. It sets up an internal mediation system. I am not a lawyer. I represented myself in the Court of Claims. I called up and I said, what do I do? And they had a form for me to fill out, and I had to pay $100. And I narrowly tailored my request. I had documented all the times I had requested this information. I started sending emails, and I would say, on this date, you told me that this report was almost done, and it's 4 months later and I still don't have it. What's the status of the report? So I attached all the emails and all the foot dragging from them. And then I went to court, and the mediation service said everything that I had was a public record, that I requested was a public record. You are not allowed, which the inspector general did, to just say, you can't have anything, it's not done. So I got them to agree to give me certain things, which I already had, but I didn't tell them that because, you know, leaking is very important. And then the day that and part of the agreement was they would have to let me know when these records would become available. Well, this is government. And so, you know, late on a Friday, near the end of the day, right before Christmas, I got my report, but I still got it. You know, you don't have to be a jerk when you're asking public records. I always start out politely and respectfully. And if they come back to me and they say that my request is overly broad and burdensome, I always know some of the stuff that I must have. And so I will say, if they tell me it's overly broad, you tell me what you think in here is overly broad. And if I can narrow it, I will narrow it. I'm amazed at the stuff that you can learn from public records. And I encourage any of you guys to go ahead and petition your government, because it's only Sunshine Week once a week, but I think sunshine is really, really important. So I am happy to answer any questions. And if they're legal ones, I'm kicking them to Gary.
Yeah, if I can just add something, a couple 60 seconds, just to supplement a little bit of what Sandy was saying. Sandy pointed out the value of requesting documents from multiple entities. Sometimes when you don't know what you know, or you don't know what you don't know, whatever, when you're requesting records, sometimes that requesting from multiple entities can, what you'll get oftentimes, if there's 3 entities that are relevant, one entity might respond with a whole lot more documents than the other 2, and you'll learn a lot more about that way. Also, you don't have to reveal when you request records what you are seeking them for. You technically don't have to give them your name or your contact information or anything like that. Although, of course, if you're not getting those records immediately and they do have to get a hold of you, they will need some contact information. And finally, I forget what it is, and I should really know for the purposes of this presentation, but I think, because of an Ohio Supreme Court decision, the cost per page is either a dime or a quarter that they has said is reasonable. The nice thing, though, is in 2021, with so much documents and information being kept electronically, many times what they'll do now is they will send you a disk with the information, and oftentimes perhaps not charge you for that, because it's not the same expense as literally copying hundreds of pages of documents to send you. So I have noticed over the last several years, we get a lot of information that we request via disk sent to us in the mail.
Let me add something to that. Thanks for pointing those things out, Gary. Sometimes if people don't know me, and the state government people, we tend to know of each other, they'll say to me, "What are you looking for?" You don't have to answer that question. And I always start with, well, I'd like answers to these questions that are in the doc. I just basically repeat what I put in writing. And some people get very aggressive and they say, "What are you looking for? Are you out to screw us?" And I always say, "I'm entitled to the information and you legally have to give it to me. And I would really appreciate it if you do." So you don't have to answer them. If you feel like you can't answer them, go ahead. But you don't have to.
Well, share my big tip before we hand it off to Lisa to talk about actions we can take. My big tip is if possible, you want to do your request to the different entities that are part of the problem. So you should put a public records request into the governor's office. And then, okay, they were doing something also at the Statehouse. So we need to do it to the Ohio House clerk, and we need to do it to the Senate clerk. That whenever you can get as many requests as possible, more likely, like what happens often is one entity will give you, and you will see that another entity, even if they're on the same email, for example, they didn't share it. And so it's cover your bases if that's an option is my thing. And then Lisa, if you're ready to tell us what we should be up to.
Yeah. And I know there's a lot of questions going on, just because it's a lot of, it depends, as Gary was saying. So I will address the one question regarding how do we know if during redistricting process, all these backroom deals, and the good thing is we know that they have provided them in the past. And we are preparing as a Fair Districts Coalition to properly request public records from the Ohio Redistricting Commission and the legislators. So we are certainly thinking about that. And so there will be different kinds of actions that we expect. So there's a delay in the census data because due to the pandemic. So, there's a potential that we're going to have to move quickly, which will create some public records. But it's also about staying on top of the process. So having public input on the redistricting process is going to remain really important. And right now, public input on any process at the Statehouse is very limited because legislators are not allowing for virtual testimony. So that is a very frustrating process for advocates and lobbyists because we don't want to risk our health. So we don't know what's going to happen with the pandemic. And we want to be able to have virtual testimony all year round. It doesn't really make any sense. So the one thing you can really do is kind of focus in on the leadership of the Ohio Senate and the Ohio House. So that's Senate President Huffman and Speaker of the House Cupp. So we recommend calls at this point, though there are emails and other options that we'll drop in the chat here for you. So I think Tiffany already did it because she's amazing. So in the chat you can find an action item for that. So this will allow us to prepare as much as we can for the redistricting process, which we know will likely have its shares of public records difficulties. And so I think I'm going to toss it over to Catherine now as well.
I just wanted to say thank you all for joining us today. There were a few other questions, but I wanted to highlight that in 2011, following the map making, we did a public records request. And this is funny. Our name at this point was the Ohio Campaign for Accountable Redistricting. We've come a long way to just be fair districts. But, and Tiffany, if you will throw the elephant in the room into the chat, I wanted to highlight a document that was created about redistricting that was due to a public records request. And so this is a request that went to the governor's office, and it went to the Ohio House, and it went to the Ohio Senate, and we did kind of individual ones with legislators, and we had boxes and boxes. I should have counted them, but so many boxes, and then we got things on discs. And what I think is important is we were able to get a clear picture of what was going on with the map making and the communications between the consultants. And it is one of the reasons why we really pushed when it was time to do the state legislative redistricting reform and the congressional redistricting reform, that we really had an eye on making sure that our district lines are not drawn in a bunker out of public sight in a hotel room, 500 feet from the Statehouse, that in fact, that the process be more transparent in 2021. Well, we are here. And one of the things that we really need to do is make sure that the process is as transparent as possible, and that they feel the pressure. Transparency and talking about public records and open government, this is all about making sure that the maps are created so that they're accountable to us and that they're fair and they reflect what we passed. And what we do know is we can pass good things, and good things can be in the Ohio Constitution and they can be in law, but a little bit of extra nudging can make an enormous difference. And so this part of things, this part of being a part of a transparency team for the fair districts, really is about how is it we can watchdog this process. And Tiffany's going to throw into the chat a link that will give you some different options for ways to get engaged with fair maps. And so as we think about it, yes, there's a speakers bureau, and yes, we have people that are doing community mapping, and we are going to do this really cool redistricting competition that is similar to what we did in 2011. So there are ways that we're going to put a ton of pressure, but the transparency and doing public records requests and really paying attention to what's happening in those committee rooms is extremely important. I wanted to say thank you all. I don't know if you noticed this wonderful image here. This is going to be a postcard. And so one of the things we're going to be doing is sending postcards to legislators and a variety of other actions. And I wanted to thank you all. We've almost come to 1 o'clock. There are a few extra questions, but for all of us for today's webinar, I wanted to say thank you. For people who cannot stay beyond noon because this was essentially their lunch hour, I wanted to highlight, here's Gary's email. If you have a specific question and you can't stay on a little bit longer, please just send him an email. And here's my email as well if you want to learn more about kind of the transparency teams. Also, if you want some postcards for your neighbors or a group that you're engaged with, we would be happy to send those off to you. And with that, I'm going to ask a few questions that are in the chat. And anybody who wants to stay on, please do. And so here are a few of our questions. So one of the questions that I thought was interesting that doesn't have to do with public records had to do with public meetings. Specifically in Portage County, the county commissioners recently voted to move to Zoom. So similar to like what we're doing right now. But they end up posting the audio recordings with the minutes, and they're not always on time. And so what's not clear is, like, with COVID restrictions, they can see kind of or hear what happens, but it's not the same as actually an open meeting. And so what can you tell us, Gary, about COVID and how, and what are the requirements under virtual meetings for open meetings?
Yeah, that is a great and timely question, and I will admit that I do not have all the answers to that, and I'm not sure that anybody does. Keep in mind, groups like the ACLU of Ohio and journalists and what have you maintain that, for instance, if you are a government official who discusses government business via your private cell phone and you text others about this, that should be a public record under Ohio's laws. But to my knowledge, that is still rather an open question this many years after texting became a thing. So now, obviously, with COVID-19 and its impact on government business and government meetings, what we have is a lot of government entities scrambling to hold meetings, to make decisions, make it accessible and available to the public. But how exactly does this process of using Zoom or other technology fit into open meetings, or for that matter, public records laws? And I would like to think that it shouldn't make any real fundamental difference with regard to these issues. But I also have a feeling that courts will be weighing in on this at some time in the future. So this is sort of a new world, let's say, for open meetings, and in particular with regard to Zoom. And it will be, should problems arise, it will be a number of years, unfortunately, until we get this all sorted out.
All right, now I have one. This is from Sue up in Cleveland. She says, does it make sense to have multiple people call about the same records request, or multiple people submit requests, the same request?
Yeah, I don't know if you have any thoughts about that. I think, the more the merrier, because sometimes, just like when you request records from multiple entities, if you have multiple people making essentially the same request over time to an entity or multiple entities, you might get different responses and different documents back. One thing that Ohio news reporters and news reporters around the country do, not every sunshine week, I'd say maybe every 2 to 3 years, is they will conduct a survey around Ohio, and they will make public records requests for the purpose of determining how well do government officials responsible for facilitating government requests, how much do they know the law, and how compliant are they with the law? And unfortunately, whenever they unveil these studies or projects every 2 or 3 years or so, there is a shocking lack of knowledge among those people responsible for getting us our records as to what exactly the law is. One of the struggles with this, again, is dealing with a lot of people that don't know the law. Now, they do take training, and the Attorney General's office provides training, and at least in the past, I know it's been very good training with regard to this. But in many areas, and I don't think it's limited to whether it's a big city, a small city, a suburb, a rural area, across the board, you run into problems with people who do not know the public records law. And then sometimes, as I'm sure Sandy can attest to and has talked about, you get into a debate as to what exactly you are entitled to or not.
No, I think you're right. I think there's safety in numbers. The more people who request it, the more likely it is that you'll get the public records that you want.
And we didn't get a chance to talk more in depth about what to do if you're denied. So I'm going to handle that here in 30 seconds because I know there might be questions about it. You can do 4 things. You can, number 1, give up. You can, number 2, keep pestering the people that keep the records, which is something I know Sandy and myself and others are well acquainted with to finally get those records. You can file a lawsuit in the Common Pleas Court or directly with the Ohio Supreme Court. It's called a mandamus action to try to get records. Or several years ago, to his credit, then Senator, now Auditor Keith Faber created a process within the Court of Claims and primarily within the Court of Claims. Sandy was talking about that earlier, where it was much easier for her to go in and get those records. The problem is that as far as the Ohio Supreme Court is concerned, is that people were continually filing lawsuits to get records and taking up court time when they were clearly entitled to these records. There was no question about it. But the unfortunate truth is, if you are Joe Citizen, let's say, oftentimes you will get turned away or discouraged from obtaining public records by the officials that keep them. And so, you think about filing a lawsuit at that point. The Ohio Supreme Court does not want to deal with these routine public records cases. And so this expedited, much more efficient and easy process of going, for instance, to the Court of Claims, where you pay at least $25, where it's resolved much quickly, where it's cases that are easy. If it's still a difficult case, if it's still unclear what the law is, that might very well still be kicked over, for instance, to the Ohio Supreme Court or another court. But there is a process now, again, that's easy. You don't need an attorney to do it. We have the instructions for how to do it in that ACLU of Ohio guide that we linked to and I talked about. So there are 4 different ways to do this. But if you go the non-court of claims route and file what's called, again, a mandamus action with the court, that's going to take a long time, more often than not. That could take potentially years before you know if you're entitled to those records or not. And the court of claims process, again, is much simpler, much more efficient. I have heard nothing but good things from people who have engaged in that process.
All right, well, so we have an interesting question here that has to do with kind of quasi-governmental things. What about a big group comprised of ex officio members? So the district advisory council appoints members of the Board of Health. Are their deliberations public?
I think then we get into the it depends issue. If this is information that the government is relying on, for instance, you have these ex officio people who are recommending things to government, who are receiving information, sending it along to city council, the county commissioners, what have you, and they are sending and receiving those records as part of their normal business that documents the functions of the government or that they rely on. Yes, under Ohio's public records laws, generally you should be entitled to those records. Where it can get a little bit messier is when you start to get into these issues of, does the government fund them or not? Does the government provide any oversight or not? Was it created by the government or not? And one thing that the court is particularly concerned about is government entities that may create a private body or a quasi-private body with the express purpose of avoiding Ohio's public records laws. So the court has been on the watch for that particular fact pattern, that you can't just simply remove your obligation under Ohio's public records laws by creating a private or quasi-public entity to perform the same functions.
So this is something that you said before, but we got an additional question. I thought it might be worth clarifying for folks. It has to do with the cost of the copies. How do you avoid that?
Yeah, if it's a paper copy, and it takes them time, and I think it was either mentioned earlier or it was in the chat or it's in one of the documents. When you're talking about what you are on the hook for regarding expenses, it's the actual copying of the paper. You don't have to pay for, although they might try to charge you. You don't have to pay for the staff time that is spent tracking down the copies, rooting through the boxes, those sorts of things. I mean, generally speaking, that's covered under the fact that they are a government employee doing their job, essentially. But there is no real formal way under Ohio's public records laws to avoid that expense. But as Sandy said when she was speaking, you can ask, certainly under FOIA, that federal process for getting federal government records, there are exemptions in there. There are media exemptions. There are other exemptions that would make you not liable largely for those costs, or sometimes entirely for those costs. Again, that doesn't exist in Ohio. Now, you can ask, and sometimes they will not charge you. Sometimes you can say, yes, please bill me for the cost of these records. And sometimes with the ACLU, they just simply send the record. Again, I see that more and more. as documents are kept electronically and then just burned to CD and sent to you in the mail. They don't even bother, many times trying to charge you for that, at least if you work for the ACLU. And believe me, ACLU gets denied records plenty. Just because we're the ACLU doesn't mean we automatically get these records or anything. But so again, it's I forget if it's a dime or 25 cents per page, but essentially you're on the hook for it. You are, unless they are kind and deferential to you, and that they don't charge you, and that does happen. But technically, under the law, you are responsible for the cost of those copies.
One way that I have avoided it in the past, it has to do with this. I've offered to go there because you can go and review these documents. So I've offered to go there, review them, and I just brought a portable scanner with me. So I've done this at, like, for example, boards of elections, where they're like, oh, you'll get the records, we'll get the records to you in a few months because it takes us a while to copy it. I'm like, well, what if I went there and I actually scan them while I'm there? Is that okay? And so that worked really well. So there's some other kind of, I've done that with the Ohio Environmental Protection Agency, for example, where you literally go to the office. And obviously during a pandemic, that's not necessarily something we can do. But if you're thinking about kind of alternatives, that's a decent alternative. Now, Lisa, are there questions that I somehow didn't get to, or things that you wanted to cover?
Well, I'm thinking about in the way, we covered a lot of it. I mean, in the way that, thinking about the redistricting process, do you think there's anything specifically that people on this call could be on the lookout for, like how to support our redistricting efforts to ensure that we're getting all the records that we need, or that they're hearing of something? Do you think there's anything that people on this call could do?
I would certainly, if she's agreeable to it, kick that over to Catherine, if that was meant for me, because she has a much better handle on the mixing of redistricting efforts and public records and open meetings.
So one of the things that we know is that the state legislature and the Secretary of State's office is in a process of getting ready to get the Ohio Redistricting Commission up and running. They're going to have to be making choices about vendors. There are a variety of different requests that we can do. So now one of the things that I know is that the ACLU has actually put in a request for some documents. And if you're the kind of person who was like, I would like to help to be a gentle nudge, that is something that could be really helpful. So if you're somebody, one of the things that we do know is that being very persistent and calling on a regular basis and saying, oh, we've been waiting a little while. And this, I don't mean to, this is not the kind of stalking scary. This is just like, I'm checking in, what's going on. If you would like to be part of that kind of process with us, we shared my email before, please just let me know. This, and I suspect as we go further into 2021, it'll be clearer where we're not getting information, and we may need you, much like the push for virtual transparent testimony, so that we, right now when it's not so safe to go to the Statehouse, we, it's clear that we need to be able to testify, not just with redistricting, but with a bunch of other things. And it's very worrisome to go to the Statehouse, which is why we need this virtual testimony. So we've identified that right now. I think the further we'll get into the year, it's going to be clearer and clearer where we're missing pieces of the puzzle. And I noticed, like, Bill Lyons asked a couple different times about how you know whether you got everything. And the truth is, we don't. And it's why it's why it takes a certain amount of persistence, and why it can be helpful to approach it from different angles. And with that, any other questions or comments from either Sandy or from Gary to send people off and to enjoy the rest of Sunshine Week?
I have one suggestion. When I was with the newspapers, they always did readership surveys. And the most read thing in the newspaper was letters to the editor. I always thought the most read thing should be the things that my bureau produced. But letters to the editor have a real big impact. So, send a letter to the editor and mention your local legislators by name. They read those too and say, I'm really concerned. I know we're making the new map. I want it to be fair. I want it to be balanced. I'm tired of the minority party getting all the votes. And I want to encourage legislators, whoever lists their names, to do the right thing and stand up for democracy. Every newspaper has a list that says how many words they like in their letters, and they tend to not run the ones that go over the word limit. So Google letters to the editor and the name of your hometown paper, and then make sure that you keep to that limit and turn it in. And I think that you got a real good shot at getting them in print.
And I will echo what Sandy said. There's also a link in the chat regarding letters to SPs in the state. I can say that they do read those letters to the editors, and their aides definitely make them aware when they are mentioned in the paper. So I think that's probably all that we have time for today. I hope we answered as many questions as we could, and I'll pass it to Catherine to close it out. But we thank you so much for attending.
Well, I just wanted to say thank you to everybody for participating today, and we'll be sending you the slides, a recording, and a little bit of information about other ways to get engaged. And we just wanted to say thank you. You all have a good day, and thank you again. Happy Sunshine Week. Bye, everybody.
Thank you.